Good morning. My name is Corinne McGuffin, and I'm the Economic Development Manager in Ards and North Borough Council. And today is the second part of our employment law update. So this is part of our series of webinars that we have been organizing as part of our economic development program. And so today we are working in partnership with Juhan and to support our local businesses and to propose an update really on employment law. So I will not keep it very long. I just want to introduce the speakers. So we will have Jack Palmer and Patricia Rooney, both partners at Juhan, and they will be delivering today's webinar. So we'll concentrate on employment, and we'll touch on a variety of issues today that business are quite worried about, understandably. And for example, we'll be looking at the end of the Furlough Scheme. We'll be looking at how to deal, for example, with vulnerable employees, redundancies, alternative working arrangements. So all that, I will leave it in the hands, the capable hands of Jack and Patricia. So I'll ask you, to maybe look at the bottom of your screen as well, and you will see that you have a button that says Ask a Question. So if you have a question, please enter it there, and our speaker will be very happy to answer at the end of the session. We will have a question and answer session, and so at the end you'll be able to ask as many questions as you want. And if we can't answer them all, then we will follow up with you if you leave your details. So I'll pass on now to Jack, and up to you, Jack.
Thanks, Karina. Good morning, everyone. Thank you for joining us a lovely summer's morning. So yeah, we just go to this morning I'm going to be talking about planning for the end of the furlough scheme, and in particular dealing with issues with vulnerable or reluctant employees that might arise out of that. Patricia will then be looking at how to carry out a redundancy process, and then also looking at working from home arrangements going forward. Okay, so obviously the scheme has already changed, and we should briefly remind ourselves of how the scheme is set to wind down before it closes at the end of October. So the level of support available decreased at the start of this month, with support for NIC and pension contributions removed. So as we move into September, you'll see that the level of support for wage costs is going to drop. It's going to drop to 70%, and it'll drop again, then 60% in October, as the scheme tapers down. Yes. So one of the most common issues that we've seen over the last few months is employees disputing a decision to bring them back from furlough leave. So while the scheme is running, it's important to remember that the decision of whether or not to furlough an employee it's at the employer's discretion, entirely at the employer's discretion. And given this, the basic premise is that employees should be available and ready to return to work once they're notified that the furlough scheme is ending, whether while the scheme is running or from 1st of November onwards. So finally then, it is important to remember that furloughed employees will return to work with exactly the same employment terms as before, including around pay, contractual benefits, hours of work, everything else. So if you do want to change employment terms, you will need to consult and agree those changes, just in the same way that you would do otherwise. Yeah. So it is the unfortunate reality that a large number of redundancies are expected once the scheme ends. Many employers are facing what you have to say is a very difficult trading environment. There are obvious cash flow issues across businesses in a number of sectors, and everyone will have seen the thousands of job losses already announced across the UK in the past few weeks and months, as businesses prepare to make redundancies either before or at the point that government support is withdrawn, which is obviously currently 31st of October. So unlike other countries such as Germany or the Netherlands, this isn't actually prevented by the job retention scheme rules. So UK employers can make furloughed employees redundant and claim support for notice pay under the scheme itself. And that is a quirk of the UK scheme compared to other European nations who have similar schemes in place. So Patricia will look at this in more detail. So I will concentrate on the employees whose employment is going to continue after the scheme ends. Thanks. So again, while the basic premise is that furloughed employees can be brought back to work, we are, of course, we're talking about people. We're talking about employees with a range of personal circumstances, and you will need to consider the employment law implications, which can arise. So we've grouped these into 6 sort of main categories where we would anticipate there being some issues around the return to the workplace. So the first of these is vulnerable and previously shielding employees. Throughout the pandemic in the UK, there have been 2 tiers of vulnerability: vulnerable and extremely clinically vulnerable. And only those in the second category were required to shield. Those who are considered vulnerable but not required to shield have been able to attend their workplace throughout, as long as that's necessary and subject to risk assessment and so on. And now that the guidance on shielding has been paused in Northern Ireland from the 31st of July, any previously shielding employees can also be required to return to the workplace. Again, if needed, if they can't work from home and subject to risk assessment. So really, employees who were previously shielding are now in the position that those categorized as merely vulnerable would have been in throughout. So again, the prevailing recommendation is still that where an employee can work from home, that they should. It's very likely that those who are or have been previously shielding will be nervous or reluctant to return to the workplace, and employers should act reasonably and fairly in reintegrating them into the workplace. This should be supported by a robust risk assessment and any necessary physical adjustments to the workplace itself. And we're thinking glass shields, that kind of thing, just depending on the environment that you're in. It will also be worth thinking about whether you can put in place staggered schedules to allow more vulnerable employees maybe to arrive at a less busy time or leave at a less busy time, taking into account if they're using public transport and so on. If there are measures in place that allow you to do that, and if your office or site has capacity for, say, 10 employees 2 meters apart, if you can stagger work times to allow for that to happen. So it is worth noting that since shielding has been paused, it is no longer possible to shield. So these persons are no longer going to be eligible for statutory sick pay, purely on the basis that they were shielding, because shielding itself is no longer operative. So you would really have to deal with absence and pay during absence based on your own policies and the position on statutory sick pay which existed before the shielding guidance was released. So many previously shielding employees will have a condition which constitutes a disability under the Disability Discrimination Act, and you will need to consider whether you can make reasonable adjustments for them in the same way as you would do with other employees and with other unrelated disabilities. Again, this might include permitting them to work remotely or in an isolated area if you can do that. Physical workplace adjustments, changes to hours, to less busy times, and you should take any relevant disability that you're aware of into account in your risk assessment process. Pregnant employees, this has been an area where we've seen some confusion during the response to the pandemic. Some employers have excluded pregnant staff from the workplace and either paid them sick pay or furloughed them. The legal position now and throughout from March to date is the same really as it's always been, in that as an employer, you must ensure that you provide a safe working environment for pregnant employees. And where this cannot be done, then the employee should be suspended on maternity grounds, and that would be suspension then with full pay. So employees with care responsibilities, schools reopening in September or this week may ease the burden on some parents, may add stress for others. However, the base position is that employees who are caring for a dependent, whether that's a child or a vulnerable relative, anyone, will be required to work unless they've agreed a period of leave. And we will go through the types of leave which are available. Reluctant employees, then, undoubtedly there will be some who, for whatever reason, are reluctant to return from furlough leave without having any obvious health or welfare concerns to take into account. And again, the base position that these employees are required to attend work as instructed. It's the employer's decision to end their use of the furlough scheme or when the scheme naturally concludes. And refusal to return to work with no good reason would constitute a disciplinary issue. And it is something which you could eventually deal with under your existing disciplinary procedures, and it could eventually result in dismissal. However, it is very likely that tribunals will expect employers to take a reasonable approach and be responsive to any genuine concerns which are raised by employees around their safety, keeping in mind, of course, that there's an implied duty of trust and confidence between employer and employee, which you should always be trying to act within. And of course, you do not want to be seen in any circumstances to treat an employee who's raised what they feel is a genuine health and safety concern less favourably or subject them to some sort of a detriment, because that in itself would also give rise to the risk of a claim. So to this end, again, you should have robust risk assessments and clearly communicate new safety measures to staff, giving them enough information essentially that any refusal to attend the workplace then would be more unreasonable on their part. Okay. So when employees do come back from furlough, they will be returning in what we're all calling the new normal of social distancing and increased hygiene measures. This means that premises that were perfectly safe 6 months ago might not be suitable now. So concentrating on the employment law implications of this, aside from the obvious health and safety issues that it presents, it might be necessary to take measures such as varying shift patterns, rotating between office work and homework, and so on, just to ensure that your workplace is what is being dubbed Covid-19 secure. Some employers are adopting more invasive measures, conducting screening processes, including temperature checks. Where you do conduct health checks on employees, you will need consent from an employment law perspective. There are also data protection issues, and you would be looking again at consent to process that data, or you'd be looking at a vital interests ground for processing. But in the main, you should be really being upfront with employees about the measures that you want to take, why you want to take them, and essentially obtaining their consent in some way to that. Okay. So once the scheme does come to an end, we will be back essentially where we started in March, and employees who still want or need to take time off will need to rely on the pre-existing statutory leave types. So again, there's a wide range of personal circumstances for employees who could be effective. Some will be struggling with childcare and may request a period of parental leave, which is usually unpaid unless your employment contracts or your policies state otherwise, and that would just be parental leave in the usual way, subject to the rules of the statutory scheme. Where an employee is reluctant to return to work due to a genuine safety concern or other personal reasons, and you agree with them that in their circumstances you're happy for them to remain out of the workplace for a period, you can agree just to have a period of unpaid leave. All employees are entitled to reasonable unpaid time off to care for a dependent. And we can contrast this with the leave which is available in the Republic of Ireland, in that in the UK, this leave is really only to deal with emergency situations and make arrangements then for further care. It is not intended to cover longer absences, to give care or supervision to dependents, children, etc. So a good example of this, where this could become relevant, is where a school has to close at a short notice, and a parent will, of course, need to leave work to make immediate arrangements to care for the child. But and that's fine. You can use the dependence leave for that. But if you become aware that the school will be closed for a week or 2 weeks, this leave really is only designed to deal with the immediate arrangements for further care. So an employee would not reasonably be able to extend their period on time off for dependence leave to cover the entire period of the closure. So finally then, if you do conduct a risk assessment of your workplace and find that you can't provide a safe place and system of work for some employees because of the risks which are posed by coronavirus, and you have to exclude those employees on this basis, these employees can consider themselves as having been suspended on medical grounds, and those with over 1 month's service would be entitled to full pay for up to 26 weeks under this type of leave. So this will apply, and we can distinguish it from where an employee feels that they aren't safe to return to work. This is where you, the employer, feel that you can't provide a safe place of work, which is of course one of your statutory duties towards your staff. And in this situation, you're telling employees that they have to be excluded from the workplace. And that is why the suspension which follows would be on full pay. Also then, annual leave. We'll deal with the issues arising from annual leave in the next slide, but obviously annual leave is available. Many employees should indeed be encouraged to take annual leave at the moment to prevent build-up, and that could be a way for employees who maybe aren't happy to come back straight away or aren't happy to come back full-time straight away to manage their return to work and the hours that they're working when they return. Okay. So we do need to prepare for a number of the more obvious issues which are likely to arise as furloughed employees begin to return to the workplace. Many, especially those who have been shielding or those who do have a relevant disability or other condition, will be concerned for their safety and they will be reluctant to return to work. And we would expect that for some, this will unavoidably cause additional stress or anxiety, which will then result in a period of sickness absence. And again, these absences will require careful, cautious treatment, given that tribunals will expect employers to act reasonably in what are unprecedented circumstances in accordance with the duty of trust and confidence which passes between employer and employee. So really what we would be recommending would be a constructive approach to dealing with concerns that employees have about returning to the workplace, taking them at face value and treating them as genuine concerns and trying where possible to work through them. And then if you do feel a concern isn't genuine or isn't shown by the the reality of the safety measures that you've put in place, then that's obviously a different issue. There will be, as I said, there will be some cases where employees simply do not want to return to the workplace without good reason, or indeed fraudulently claim that they are ill. Repeated unauthorized absence or fraudulent use of your sick leave policies would be dealt with under your disciplinary procedure. This could eventually result in dismissal, again with the proviso that you should act with care and caution in this period of really unprecedented disruption. Some furloughed employees will be concerned about their job security and potential redundancies, especially given what's on the news and the sort of general climate at the moment. And they may need some reassurance from you, essentially that they have been placed on furlough, but this hasn't prejudiced their employment rights going forward. This will be especially true for employees whose roles have been covered by someone else during their absence, or employees returning from furlough who will be initially asked to perform a different role than they did before, or to do less work than they did before because business has slowed. Those employees may be very concerned about the safety of their employment in the long term. They may need some reassurance, and you do need to be careful that when you are reassigning duties, that you do it in a way where employees don't feel that their role is being made redundant without due process and so on being followed. Another consequence of furlough is that many employees have built up large annual leave balances due to travel restrictions, due to cancellations and so on. These can be reduced by assigning annual leave, and you can do that while employees are still on furlough or after they return, so long as you give the correct notice, which is a 2-to-1 ratio of the notice you need to give against the amount of days you want an employee to take. Many employers are also saying to their employees, look, you need to book 5 days by this time, or we will assign days for you. You want to avoid a situation where the scheme ends in October and you have every single employee trying to book leave at the same time, or trying to book leave at Christmas, for example, at the same time. So the working time regulations have been amended to allow employees to carry over annual leave, which it wasn't reasonably practicable for them to take as a result of the effects of coronavirus on them, on their employer, or the wider economy or society. This new amendment regulation applies to 20 days leave, which is granted under EU law, or the pro rata equivalent for those working part-time. And while the statutory language is quite ambiguous in terms of the effect on the worker, the employer, or the wider economy or society, the government guidance, which has been published relating to GB regulations, but which would be authoritative in Northern Ireland, this government guidance indicates that the emergency provisions around carryover of annual leave is not intended to cover practical difficulties with taking leave during the lockdown period, such as holiday cancellations, flight cancellations, travel difficulties. The carryover provisions are really intended to deal with situations where an employee has not been able to take leave because they're performing a key function and they can't take leave, where there's not enough cover for them to take leave, where them taking leave would impact the ability to respond to the difficulties posed by the pandemic, etc. So finally then, Patricia will look at this in more detail around home working. But given that many employees have enjoyed working from home over the last few months, it is very likely that there will be an increase in requests for flexible working arrangements, whether that's in terms of the hours an employee works or the location that they work from going forward. And it would be a good idea to prepare now, looking at your operational needs, your staffing needs, and really thinking about how you can respond to these requests when they are received. Okay. So looking ahead then, it does seem unavoidable there will be redundancies as a result of the disruption over the last few months, especially when the job retention scheme closes. However, it is worth noting that many employers are taking some measures to protect their financial position, and this has included freezing promotions, freezing pay increases, freezing discretionary bonus schemes, assigning annual leave so that there's less holiday pay on termination essentially to be accounted for. These are all measures which are potentially available to you. Obviously, where you're looking at withdrawing a bonus scheme, you do need to make sure that the scheme is discretionary and you do have the ability to withdraw it. Okay. The government has announced a job retention bonus of £1,000 for each furloughed employee who is continuously employed from the close of the scheme until 31st of January 2020. An employee needs to earn £520 per month on average between November and January to qualify. So while any support is helpful, of course, whether or not this will be a deciding factor for businesses in whether or not they can retain their full complement of staff will inevitably vary greatly depending on their own financial position. So overall, as the scheme is set to end in just over 2 months, it is a case now of accessing as much support as you can while you still can, while the scheme is still open. We quite simply don't know, and we can't really predict whether the scheme will be extended or replaced by alternative measures in November. Currently, around 12% of the UK workforce is furloughed, which is roughly around 3 million people. There will be substantial pressure on the government to take some action, but we do need really to wait and see what that action is. It is instructive to some extent to look at the measures taken by other comparable countries in Europe. When we look at, for example, Luxembourg, they have not given an end date for their furlough scheme. France has indicated that their scheme could run for up to 2 years in some form. Spain has committed to the scheme running until the end of December 2020. Germany and Sweden, likewise, their schemes at the moment will close at the end of December. And I can see from the poll which we have run that it's unanimous really that I think there is definitely an appetite for the UK to follow suit and extend the scheme in some shape or form rather than let it run out at the end of October. So with that said, I will pass you on to Patricia, who will go through redundancy processes and then on to homeworking.
Thanks, Jack. Good morning, everyone. I have the task, at least in the middle of this presentation, to deal with the unsavoury topic of redundancy, but still an important topic, so you are aware of the process that must be followed. There are statutory grounds which justify dismissal on the grounds of redundancy, and I've set them out there in that slide under part 12 of the Employment Rights Order. But if we move to the next one, Kat, please. Essentially, what you're looking at as a valid ground for redundancy, you can see there is where you have to close your entire business. There's a reduction in the business. There is a closure of the site where the employee actually works. That could be a factory or a shop, or your business needs less people doing the work the employee actually does. So those are the 4 main grounds that you could use to justify a dismissal on the grounds of redundancy. Now, once you have those grounds established, obviously there's a process that you have to undertake. and some essential factors, if we could move to the next. So where you have a redundancy situation, the main components of ensuring what you're doing is right is that you have a fair redundancy process, that you pay a redundancy payment if the employee is eligible, and we'll look at that later, that you consider the possibility of alternative employment to avoid a redundancy, and also something that is overlooked quite a bit, that someone who is to be dismissed on the grounds of redundancy is allowed reasonable time off, which is paid, to look for new employment. So if we look at the redundancy process first, then that's the next one. And remember, even if you have one of those grounds which would justify the termination of employment on the grounds of redundancy, you still need to carry out a fair process. And the absence of a fair process in itself could make your dismissal unfair. So what you should do, as Jack mentioned, you should consider ways to avoid a redundancy. That might be stopping a discretionary bonus, withholding a pay rise. Again, as Jack said, providing that they aren't a contractual entitlement for the employee. You might limit recruitment, you might stop overtime, impose reduced working hours, and also if you have agency workers, consider whether you need those agency workers. You then have to consult with the affected employees. That's those employees maybe who will be made redundant themselves, but whose terms and conditions might be affected if they are asked to take on additional duties or work in a different place. So affected employees are those who are at risk of redundancy, but also other workers, as I say, whose terms and conditions might be just tweaked or changed. You must adopt a fair selection process, and I'll look at that again. And also your process, your redundancy process itself, should contain a right of appeal against dismissal. So the first thing to look at on the next slide is your consultation with employees. If you are unfortunate enough to have quite a large scale redundancy, collective consultation obligations might be triggered. And as you can see there under the 96 order, you will have collective consultation obligations if you are proposing to dismiss employees at one establishment, essentially their place of work, 20 or more employees within 90 days, or 100 or more employees within 90 days. And those periods of 30 days and 90 days means that your consultation process should start 30 days before the first dismissal, where you've more 20 or more, or 90 days before your dismissal, where you're proposing to dismiss 100 or more employees. Now, these are statutory obligations, and I'll tell you what, unfortunately, the consequences are if you fail to comply with these statutory obligations. And with collective consultation, your obligation is to consult with employee representatives. And those are the four things that you should be discussing or consulting your employee reps about. If you remember, a consultation process is primarily designed to see if you can avoid dismissal or reduce the impact on the workforce as a whole. So with your employee reps, you will consult with them as to alternatives that could avoid any dismissals at all, or perhaps reduce the numbers of roles that are going to be declared redundant. Again, mitigating consequences of the dismissal and reaching agreements. That might be things like discussing and agreeing the selection criteria that you're going to use, or the process or the mechanics of dismissal, or the consideration of suitable alternative employment. So there are a few matters there that you must consult your employee reps about. Now, your employee representatives might be already in situ. You might have a trade union. You might have an employee forum or a works council, and the latter two organisations have the capacity or the arrangement to discuss with the employer about dismissal, termination, change in terms and conditions, etc. If you do not have an existing employee representative forum or a trade union, there are obligations that would require you to allow the employees to arrange a ballot so that they can select their own representatives. But again, this is for the purposes of collective consultation, where your collective consultation obligation is triggered when you are unfortunately proposing to dismiss 20 or more. So if we can move to the next one. So the information that you are going to provide as part of this collective consultation process, and as I said, you will provide it to the employee representatives, is why there is a proposed redundancy situation. And if you go back to the reasons that you would have, the valid reasons for a redundancy process, that could be, unfortunately, the business is closing, or a particular site is closing, or you need less people to do the same amount of work, or there is a reduction in the work required itself. You also must disclose how many employees do you think are at risk of redundancy and the roles that they carry out. In other words, there might be 2 operatives and 3 supervisors, or 2 sales assistants and 4 supervisors. So it's the number and the category of employees. And then you would add all of those up and give the total number of employees at risk. You should also consult and, as the previous slide said, possibly agree the selection method, the criteria and the procedure that you're going to adopt to actually pick the roles that are at risk of redundancy. And also to disclose what payments that you will be paying on redundancy, whether that is the statutory redundancy payments or whether you are deciding to introduce an ex gratia, or perhaps you already have a redundancy policy which sets out exactly how much you will pay and indeed what process you should undertake. If you do have 20 or more people that you are proposing to dismiss, you must notify the Department for the Economy. There's a set form for doing that. It includes much of the information that's set out in the bullet point above. You know, why, how many, what timescales you have, when do you think the redundancies are going to take effect. So it's information that you will already have that is to be completed on that form, and it is given to the department before your dismissal takes effect. As I've said, this is a statutory obligation to consult collectively with employee representatives. If you fail to do that, the representatives on behalf of all of the affected employees, or an individual employee, or in fact all of the employees, can take a class action for alleging there's been a failure to properly inform and consult. Now, that is a stand-alone claim which doesn't have to be tagged on to an unfair dismissal or an unfair selection for redundancy. It is simply an allegation that you have not carried out a proper collective consultation process. Unfortunately, the risk of an award is 13 weeks' pay for each employee, so it can be quite a substantial payment on top of redundancy payments if you fail to carry out your collective consultation obligations. But if we move on then and look to the consultation where you have less than 20 employees at risk of redundancy, and this is at each site. So you would look at each site or each place of work to assess how many employees at each site are at risk of redundancy. If you have less than 20, you can consult with the employees directly. And this includes consultation with those who might be on furlough leave, who might be on maternity leave, or any kind of statutory leave or sickness absence. So you're consulting not only with the employees that you can actually see in the workplace, but also those who are still employed but might be absent for various reasons. And that includes making reasonable or considering reasonable adjustments if you have any disabled employees. So you do really need to make sure that whatever consultation exercise you are going to embark on, it is appropriate for disabled employees, you might need to consider additional meetings or additional companions, or review your online platform, or whatever form of communication you are going to use in the circumstances, particularly now, considering that a lot of employees will be on furlough and not actually attending the workplace. Unlike the collective consultation process, there is no set time for a consultation process with employees directly, but really there is little point starting one if it is unreasonable or meaningful. So there's still information that you must give to these employees. And on the previous slides where I've set out what information you should give to employee representatives, you should consider that you also give that to the employees directly. The more transparent it is, the more you can demonstrate that you have carried out a full and reasonable consultation exercise. So part of that would be giving advance warning, as I've said, before the dismissals to affected employees and the workforce. Again, a consultation exercise is about trying to avoid dismissal. So if you can give as much warning to the employees and the workforce, you might get some proposals that might make you reconsider, no matter how unlikely that might be, because no employer undertakes a redundancy process without having considered a lot of alternatives. You must still consider any proposals put forward by the employees themselves. You should really give the warning to those employees who might be made redundant, whose roles might disappear, but also obviously to other departments. So you can at least give comfort to particular departments or a particular category of worker where you're not proposing to dismiss. In this case, a failure to properly consult does not bring the risk of the 13 weeks pay for failure to consult, but it might mean that your dismissals, even with a good reason, could be considered unfair because you failed to undertake a proper consultation process. So if we just move to the next. If you have a number of employees at risk of redundancy, you must undertake a selection process. I think maybe we've missed one, Kat, have we? Can you go back? Yeah, thank you. So as I've said, your consultation process, then it is up to you how you start that off, but it must be reasonable considering the diverse nature of your workforce, and as I've said, where they are they working, are they in flexible furlough, are they on any kind of statutory leave? So you might start it off by a group meeting, and as I've said, that is to those who will be personally affected because their role might be at risk of redundancy, but also to those who might be, their work might be disrupted, or they might feel that they are at risk. So it's up to you how you do that, whether you do it by a group meeting, a memo, or an email. But immediately after then, you should be starting individual consultation meetings with those employees whose roles are at risk of redundancy. We would usually recommend that you have at least 2 of those meetings with an individual before the dismissal meeting. Of course, check your own policies and procedures if you have a written redundancy policy, and also consider whether you will allow the individual the right to be accompanied at these consultation meetings. There is no statutory right to be accompanied at a consultation meeting. I'll come to a dismissal meeting later on, but again, you might actually find it easier if the worker or the employee has a companion. We always recommend that you have a note taker present at the meetings because it is much easier to conduct a meeting for both parties, for the person who is conducting it from management or the company, and also the employee to know that there is a free flow of information and that somebody else is taking notes. And of course, they will be discoverable, and the employee could ask for them in any event as part of a subject access request under GDPR. As I said, do remember that your consultation process is to include absent employees. So you will have to consider how you're going to consult with those who are in situ and those who are absent. So if we move to the next one, if you have a number of employees, you do have to undertake a selection process. The selection process and the identification of the pool of employees or the category of employees who are at risk of redundancy is a matter entirely for the employer. So you might identify a pool of employees who carry out similar roles, who are sales assistants or administration or supervisors, or who have similar skills. Again, it is up to you how you categorise that pool of employees, but in doing so, how you select them must be fair and easily identified, so it must be transparent. Once you have identified the pool of employees, you then have to consider what criteria you will use to select the employee or employees within that pool who are at risk of redundancy. Again, the criteria is entirely up to you, and it can differ from workplace to workplace depending on the employees that you have within that pool. However, the more objective the criteria are, the easier it will be for you to justify. Length of service used to be used on its own until it was frowned upon, but you can still use it. And those 6 criteria are only examples that you might want to consider to use to select your employees who are going to be at risk of redundancy. Clearly, things like disciplinary record, length of service, and attendance are objective. You do need to consider attendance, and again, look for those who have periods of statutory leave, maternity leave, adoption leave, or have a disability-related absence. So you need to consider how you're going to mark that. Unfortunately, in practice, things like attendance, disciplinary record, and length of service will not necessarily get the employees who are best suited to do the jobs that are left. So you normally look at something like skills, work performance, so that you know that the person that you are keeping is the person best equipped to do with the job. But as I've said, do be careful when you're marking subjective criteria. And for that reason, we would suggest that if you can have 2 people doing the scoring, that reduces the possibility of allegations of discrimination, or that the employee says the manager, the supervisors never liked him or her. So if you have 2 people doing the selection and scoring, that is usually better. And again, records, if you keep your criteria, your selection matrix, etc., that will justify how you have carried out your selection process. And again, those will be needed just in case there is a challenge to the process. One employee within the pool is not automatically entitled to see the scoring of everybody else. As I've said, you will have GDPR obligations, but you could say to an employee where they have ranked in a particular list, say your scoring is 10 and they've got 5, or 1 and they've got 5. So you can do that, but you should not disclose somebody else's scoring after the application of those criteria. So if we move to the next one then, so after you've done your selection process, you will have consulted with the employee or employees and advised them of their scoring as part of the consultation exercise. You then need to arrange a dismissal meeting. Now, failure to follow the 3-step statutory process, no matter how good your selection has been or your reasons for redundancy up to this point, if you do not follow the 3-step statutory process, your dismissal will be automatically unfair. So you do have to allow the individual employee to be accompanied at the final dismissal meeting, and that statutory right is for a trade union representative or a work colleague. So if you arrange a dismissal meeting, advise the employee of his or her right to be accompanied, you can dismiss at that meeting. You then must provide a written outcome or a letter of dismissal to the employee, confirming the termination of employment on the grounds of redundancy, giving information about what redundancy payments, notice pay, etc., and also informing the employee of the right to appeal against the dismissal. You must, in the event that the employee does appeal, arrange an appeal hearing. As far as possible, that should be an independent person within the organisation who has not been involved in the redundancy process to date or the selection. I appreciate in some organisations that will not be possible, but if you can, try and remove someone from the process so that you can keep them to hear any appeals that the employee might issue. After the appeal hearing, again, the employee has the right to be accompanied at that. You must write to the employee confirming the outcome of the appeal process, and that concludes the internal redundancy and disciplinary process. Redundancy and dismissal process. You might find that there are grievances issued throughout that, but usually we find that a grievance issued in the middle of redundancy process is, in effect, a complaint about the process itself, which you might be able to deal with at a consultation meeting or at an appeal meeting. So if you have unfortunately declared someone's role as terminated on the grounds of redundancy, they may be entitled to a redundancy payment. So if we look at that next. To be eligible for a statutory redundancy payment, an individual has to have 2 years full service. Whether or not you pay an employee with less than 2 years service is up to you. And again, you need to check any written policy you have that might cover that. But otherwise, an employee must have 2 years service to be eligible for a statutory redundancy payment. The redundancy payment then is set out there. It's based on age, service, and gross weekly wage. And the current maximum gross weekly wage for consideration is £560. You can see the entitlement differs depending on the employee's age. Notice or pay in lieu of notice or holiday pay accrued to the date of termination, they're all subject to the usual statutory deductions, national insurance, tax, etc. But any redundancy payment, including an ex gratia and enhanced payment, up to £30,000 is tax-free. So you might pay a statutory redundancy payment based on the calculation set out there, but enhance that in some way. We would always recommend that if you are making any kind of an enhanced payment, that you consider a compromise agreement or settlement through the LRA, so that the employee is waiving all claims arising from his employment or its termination, and just gives you a bit more freedom. Remember, under the job retention scheme, you can claim the statutory notice that you will pay to your employee who's going to be made redundant. The notice pay that is due to the employee and the redundancy pay is calculated on the full pay, not the furlough pay, and this has recently been confirmed just on the 14th of August there by clarification and guidance from the government. So redundancy pay or notice, as I say, is on full pay, but the statutory notice can be reclaimed under the job retention scheme. There is are some fact sheets from the Department of Work and Pensions for employees and employers on redundancy schemes, and they're quite easy to read if you need some more information. So if we move on to the next topic then, that is working from home. I'm conscious of time and we'll race through this. A number of considerations. Firstly, look to your contract and see what it says, whether or not, as it usually does, specifies a place of work, or whether it has a mobility clause. Larger organisations might have a home working policy, and again, check what it says before you embark on considering a request. Your home working arrangements might be voluntary. You might be quite happy for the employees to work at home, or you might, as with our previous lockdown, might be at the employer's assistant. It might be something that you are allowing now on a flexible arrangement to facilitate a phased return, or as Jack had mentioned, it might be the new norm and a permanent arrangement whereby you have employees working 100% of their time from home. If we just move to the next one. Now, working from home requests might be a simple voluntary or flexible or informal arrangement, or it might be by way of the flexible working regulations, which we'll look at later. But in any event, however the request comes to you, I suggest you carry out a risk assessment. You should also issue a staff questionnaire, and that can cover things like health and safety at home, what equipment or IT needs you have, data security, considering that your employees might be handling confidential information, and also considering whether or not you have existing home working guidelines or a policy procedure. But engagement with your staff is really essential, and some of those factors there are things which you should consider in providing guidelines to your staff who are working from home. Now, sorry, my screen's just gone. So there is a flexible working request regime. It's a statutory process, and there are regulations which set out what you must do in order to deal with a statutory request. It can cover a flexibility can cover the actual hours, including the number of hours that they work, the days, and of course the place of work, which is what we are concerned with here. Any employee with at least 26 weeks service can make a request under the statutory scheme. It used to be that you had to have a child under 17, but from 2015 it applies to any employee. Two other things. One is that the employee must not have made a request in the last 12 months. So that means one flexible working request every 12 months. And it is a right to make a request only. It is not a right to be allowed to work from home, but it is a right to make a request and for the employer to properly deal with that. So if we move to the next. Under the statutory scheme, the process can take up to 14 weeks. It is quite regimented in that, you know, there's 28 days to deal with the request, there's 14 days to have a meeting, there's 14 days to give out a decision. So it isn't very long before those 14 weeks ratchet up. But the request from the employee to work at home must be in writing, and the employee must set out how this is going to work. In other words, what he or she is going to do at home, what other employees or colleagues might need to do to facilitate this working from home arrangement. So that needs to be set out. The employer, as I said, then must arrange a meeting to consider that. The employer's obligation is to consider the business grounds, not to consider the employee's personal circumstances. So you can refuse a request, but only on business grounds. And there are 8 grounds, and you can use any or all of them to justify refusing a flexible working request. Now, those grounds include it costs too much money, or you can't reorganise the work for home working, or there's insufficiency of work at home, or perhaps the employee working at home can't meet customer demand. The statutory process allows for an appeal and, again, a written outcome. It is possible for the employee to make a complaint to the tribunal if the application is rejected, but the employment tribunal can't question the employer's reasons, but they will need evidence if you're attempting to rely on one of those 8 grounds. So remember that if you change, as with furlough, if you change working arrangements and allow an employee to work at home, this is a change to the employee's contract. It might be permanent, it might be on a temporary basis, but you must record those changes to the terms and conditions, or if there is a knock-on effect for many of those terms and conditions, you might wish to issue a new contract. If the employee is dissatisfied, he or she could raise a grievance, or, as I've said, complain to the Employment Tribunal. The Employment Tribunal can make an award for up to 8 weeks' pay, whatever they think is just and equitable. That's if they decide that you have failed to deal with the request in accordance with the process. As I say, they cannot make you give the individual working from home arrangements, but they can make an award for up to 8 weeks' pay and direct that you reconsider the application. The employee, in addition to that kind of complaint, might also allege discrimination, perhaps on the grounds of gender or on the grounds of disability, if you fail to consider that a reasonable adjustment might be working from home. And there are LRA advisory guides on working from home. There's some health and safety executive guidance, primarily for lone workers, but they might be of use to you. And there's also information under the Access to Work scheme for disabled employees. And that was a rapid run through flexible working, but thank you.
Hello everyone. We've run over a little bit, but we've time to take a couple of questions from our audience. Let me just have a look. So we'll take one there from Claire. When someone is on furlough and not working any hours at all, can you make a deduction, for example, damage or uniform payment, as per their contract, even though ordinarily you couldn't, because the deduction would take them below NMW? So Jack, would you like to take that one?
Yeah, so the basic position is that you are only entitled to the national minimum wage for time that you are working. So during the hours which you are furloughed, you're not working. So therefore you're not entitled to the national minimum wage. So while deductions for damage or uniform, that's not specifically dealt with in the scheme rules. The scheme rules do say that where the furlough rate of pay at 80% or less goes below the national minimum wage, that is permitted by the scheme. So we would imagine that deductions for damage or uniform would be treated the same way. So for the hours that you're furloughed, your pay with those deductions could go below the national minimum wage. But as I say, it's not specifically dealt with in the guidance, in the scheme rules, but that's what the position should be.
Thanks, Jack. There's a few questions here, Patricia, on redundancy. Firstly, within the pool of furlough employees, if faced with redundancy at the end of the scheme, should we protect those within this group who are disabled or high risk before others?
It depends what selection process and selection criteria you're choosing. That if you have disabled employees within that group, you might have to make reasonable adjustments to consider their needs. Whether or not you actively give them roles over and above others really depends on how far you need to go to consider those reasonable adjustments and what skills those disabled employees still have to undertake the roles that you need. So you do have an obligation to consider reasonable adjustments, but you still are allowed to consider what is reasonably practicable for you to facilitate those disabled employees in the workplace. So you would have to check perhaps take occupational health advice to see what skills and abilities the disabled employees have to undertake the roles that you still need carried out.
We have another question there from Claire. If you've restructured a department, amalgamating roles and meaning some redundancies, can you use a selection interview to select which of the original employee are appointed into the new positions, then go through consultation with unsuccessful employees? So again, for Patricia.
Effectively, you are still using your selection methods and your criteria. If you want to do that by way of an interview, that's fine. As I've said, when you are carrying out a selection, whether it is a scoring exercise or whether it's by an interview, if possible, if you have 2 individuals to do that interview process or that selection, it just reduces the risk of some allegations of discrimination. So yes, you can. Before doing the interview, I think it would be helpful for the employees themselves to be provided with a copy of the job description or the job spec that they are actually being interviewed for, even if they have done the job in the past. I think it gives a level playing field.
I think that's all of the questions really. Someone has asked if the slides will be available. They will be made available on both the council website and the Tunes website. I'll just invite Karina on just to say a final few words before we close.
Yes, thank you very much, Kat. And yes, I think it was a very interesting topic today, and I think that we have a few more questions, but if, we haven't been able to answer your questions, you have a slide here with the contact names of details of Patricia and Jack. If you want to forward any questions that you have even to Kat, and then we will make sure that they are responded to. We will also send you a feedback form, and I would be grateful if you could complete this, because for us it's very important in council to see what you think of what the partnerships that we have, and what we deliver in terms of workshops, and how you feel we can actually look at other topics that we may not have tackled up to now. So please let us know if you have any suggestions. Everything is welcome. So if we can help in any way, shape or form, please let us know. So, but what I would like to do now, because we have really run over time, is to thank Jack, and to thank Patricia, and to thank Kat for their expertise and for their support, and for partnering with us to deliver this workshop. So a big thank you to all of you, and so I hope it was informative for you, and please keep in touch and let us know if you have any questions. Thank you.